Hey boys and girls, this is the second video on drug trafficking laws in Singapore. If you have not watched the first video, I went through a brief introduction on the concept of drug trafficking in under Singapore law. Basically, drug trafficking, most people have this concept that drug trafficking involves carrying a suitcase or drugs on your clothes or hidden somewhere and bring it through the airport. But in Singapore, trafficking includes more than that. It includes giving, selling, administering drugs for another person. Let's discuss the various cases. In the Singapore case of Tan Po Soon and public prosecutor, the accused pled guilty for consumption of drugs. He admitted that he did consume the drugs, but he claimed trial for giving one ecstasy tablet to his friend. I repeat, he gave one ecstasy tablet to his friend. He did not receive any money in return. He was charged for trafficking an ecstasy tablet, even though he did not get any money in return. So after the trial, he was sentenced to 5 years, 2 months jail, and 5 strokes of the cane. He was whipped 5 times. And for the consumption charge, he was sentenced to 3 months imprisonment, and both sentences were ordered to run consecutively, means one after the another. So as you can see, even if you give an ecstasy pill to a friend, or you give some weed, marijuana or meth to a friend, and you don't collect any money in return, it is still considered drug trafficking. In the case of Chua Po Kiat Anthony and public prosecutor, the accused claimed trial to giving one ecstasy tablet to a friend at a club. He had previous convictions for consumption and for possession of drugs 4 years before the offense. So he was sentenced to 6 years jail and 5 strokes of the cane, which was longer than the previous case I talked about. Why was he given a longer jail sentence? Very simple, because he claimed trial when he did not have a credible defense, and secondly, he had previous convictions for consumption and possession, which shows a certain pattern of behavior. In the case of public prosecutor and Aung Jeffrey, the accused claimed trial to one charge of trafficking 1 tablet of ecstasy by selling the 1 tablet of ecstasy pill to an undercover narcotics officer for 80 Singapore dollars. Now, the offender had no criminal record and was not part of any syndicate. So, for selling 1 ecstasy pill to an undercover narcotics officer, he was jailed for 5.5 years and whipped with 5 strokes of the cane. In the case of public prosecutor and Vicswan bin Muhammad Hanafi, the accused got off with quite a lenient sentence, but he was underage at the time. He was aged 20 years old, so he was eligible for not so serious sentences. So in the case of public prosecutor and Vicswan Hanafi, he pled guilty, basically he admitted, to one charge of trafficking 20 ecstasy tablets, by selling them for $560 to an undercover narcotics officer. A second charge of trafficking by selling another 20 tablets of the same drug was taken into consideration. Taken into consideration means the prosecution is not proceeding on that charge, but it will be taken into consideration during sentencing. So, the accused in this case was 20 years old, below the age of 21. He had no previous convictions. He was not part of any drug syndicate. So, the trial judge sentenced him to probation. Basically, he had to report to a probation officer, blah, blah, blah. Then the prosecution appealed because the prosecution felt that probation for selling such a large quantity of pills, essentially 40 pills, the prosecution was unhappy with probation. So on appeal, he was sent to reformative training. Reformative training is essentially a prison for young people. In the case of public prosecutor and Wang, the offender was convicted of one charge of trafficking ecstasy tablets, 344 ecstasy tablets from Coleman Street to Yio Chu Kang swimming complex, a swimming pool. She was paid $300 to transport 344 tablets of ecstasy from point A to a swimming pool at the request of a Malaysian acquaintance. And she, after being convicted of the charge, she was sentenced to 6 years imprisonment. So why 6 years? Why not 6 years and 5 strokes like the other cases? Very simple. She's a woman. The accused, in this case, the offender, was a woman, and women are not allowed to be whipped in Singapore. Now let's move on to higher quantities of ecstasy pills. In the case of Ng Wee Tong Nelson and public prosecutor, the accused pled guilty, so he admitted to the charges. He didn't waste the court's time by claiming trial, going to trial and be cross-examined, blah blah. So the first charge involved possession for the purposes of trafficking. That means you possess a drug with the intention to traffic it. Okay? The first charge involved possession for the purposes of trafficking 130 tablets of ecstasy. The second charge involved possession for the purposes of trafficking 622 tablets of a different variant, a different type of ecstasy. The third charge involved possession of ketamine. So there were 3 other charges, separate charges taken into consideration. The prosecution decided to proceed with the 2 ecstasy charges and the ketamine charges. The offender was a designer and had only one previous conviction of attempted cheating, which is totally irrelevant to the drug charge. He was sentenced to 6 years imprisonment and 5 strokes of the cane for the first charge, the possession for purposes of trafficking ecstasy, 9 years imprisonment and 5 strokes of the cane for the second charge, also for possession for the purpose of trafficking, 12 months for the third charge, consumption of ketamine. So the sentences for the second and third charges were ordered to run consecutively, meaning one after the other. So the total sentence was 10 years imprisonment and 10 strokes of the cane. So thanks for watching this second video on drug trafficking. Do stay tuned for more videos.